So I want to talk about why using LegalZoom or really any other sort of DIY online will prepping programs like Rocket Lawyer, Willing, those sorts of things. I'll call them all LegalZoom just for reference moving forward. But why using those sorts of programs can be very dangerous, like walking through minefield. There's several reasons. First and foremost, you just don't know what you don't know. So it's very difficult for someone to do an effective legal plan on their own if they don't know the full extent of the law in North Carolina, if they don't know the specific tax ramifications, specific implications for your family based on different techniques. For instance, recently did a video on leaving your home to your executor instead of to your kids and why that's important, why that may be beneficial long term. Well, LegalZoom isn't going to tell you that. That's kind of if you don't know it, then sorry, too bad. And a lot of times you're not going to figure this kind of stuff out until your family figures it out after you're gone. And that's issue number two, is you won't be around to clean up your own mess. So if you did this wrong, if you wrote in the wrong people's names, if you used the wrong strategy, if you just didn't know any better, it's not going to be apparent until you pass away. If you never have it checked on, if you never go to an attorney to have it reviewed. So the first indication is going to be when your family goes to submit the will to probate and there are issues, which can potentially lead the estate being considered intestate, meaning the will is invalid. So unlike other DIY things like installing your own flooring or painting or that sort of thing, if there's an issue, you can try and fix it. The issue with DIY wills is you may not be around to fix it yourself, and you're kind of leaving a big mess for your family. So another issue is that the probate process and lawyers who go through the probate process with clients, that informs good planning and good strategy, because lawyers like myself who help families through the probate process have seen what doesn't work. So they've seen what sorts of provisions in a will end up resulting in unintended consequences rather than just kind of relying on a form and hoping that it does what you want it to. The other issues can be blended families. So with the divorce rate as high as it is, it's not uncommon for people to marry a second time and bring their own children from a previous marriage to that new family. So you have a second marriage, each of the spouses has children from a previous marriage. Well, it's difficult to distinguish between different planning strategies to implement for that sort of family when it's just a form document, when the form is just kind of for the everyman type of person, because it is kind of a one-size-fits-all proposition. So when you have planning intricacies like a blended family, it's difficult to effectuate what you really want with a one-size-fits-all planning document. Another is making sure that your entire financial plan is cohesive with your estate plan. So what I mean by that is when you meet with a lawyer, they're going to go over everything that you own, including things that are not going to be designated or rather controlled by your will, like your 401k, like your life insurance, and those sorts of things. So LegalZoom and those sorts of DIY programs are not going to look at your overall financial situation, your overall portfolio, to make sure that everything is doing what you want it to after you pass. They're not going to make sure that your 401k beneficiary designation and your IRA beneficiary designation is consistent with the type of asset succession that you'd like to have happen. Because how could they? They can't give advice, and they're not going to talk to you directly. You're just going to fill out your form and put in what you think is best. So you're not going to get an overall estate and wealth plan. You're going to get a very general document preparation. Designating guardians can also be a big issue. So making sure that you're picking the right people to take care of your kids should something happen to you, but also that they're also on board and that there's more than one designated. So just in case they predecease you, there needs to be alternates. There needs to be backup plans. And that's kind of an issue with DIY planning across the board, is a lot of people will just think, well, I have one beneficiary, I have one executor, I have one guardian, that's all I need. Well, what if they predecease you? Or what if they renounce those roles? What if they don't want to have any part of your plan? Well, then you have no backup. Then the state's rules are going to control, and then really the whole point of being or getting a will in the first place is undermined. So especially for kids, you want to have a very protective plan in place so that they're receiving assets when they need them and not too soon. So in United States and in North Carolina, there's a Uniform Transfers to Minors Act, which says that a beneficiary cannot receive an inheritance until they've reached the age of 18. Well, you and I both know that 18-year-olds usually aren't mature enough to handle any significant sums of money. So the best planning is to kind of structure that out several years later than that, maybe 25, 30, 35, and it's going to depend on your family and your kids and their maturity level. And you know that. And working with a lawyer, that can kind of be developed and work within that, rather than, again, using a one-size-fits-all document. The other issue is that when you use a more robust and more strategic planning, like with a lawyer, you're going to have the option of putting conditions on inheritance, like incentives or carve-outs. So if one of your beneficiaries does X, they're not allowed to inherit. If they do Y, then they'll get their inheritance. Maybe that's age-based, maybe it's receiving a college education, maybe it's buying a first home or becoming married, those sorts of things. That's something that's not normally going to be part of a DIY plan, a DIY will. So if you think your family is going to be best served by more structure, more incentives included, or more carve-outs included, you're going to want to do something more robust and more strategic. We're also, when we talk about estate planning, obviously a will is part of an estate plan, but it's a long play. This is a very long-term strategy. So obviously we want the plan to work now should something happen to you in the near future, but we also want to make sure that it's going to be up to date as long as you live, so that when you do pass away, the plan is still ripe. It's not going to become stale at some point for lack of sufficient planning on the front end or lack of maintenance along the way. So one thing that I do that LegalZoom can't do, for instance, is routine checkup with clients. So my clients receive monthly emails from me in the form of a newsletter that kind of keeps me and their estate plan top of mind. So even if they never open the email, they're still seeing my name and they're still thinking about, oh, I have an estate plan, and if something happens in their life, it's going to kind of trigger that realization that, okay, maybe they need to come in to have a chat about that. So that's something you're not going to get when you're using a DIY type document. There's nobody to check up with. So if you get divorced, if you have another child, if you move, those sorts of things, there's not going to be anybody to check up on you for that. So you're again still on your own. The other issue with that is there's not going to be anybody there for your kids after you pass away. So that's also the benefit of using a lawyer, is there's going to be someone to kind of usher them through the process, either being through interpreting the documents for them to kind of spell out what you intended, or also helping them through the probate process itself, and maybe even representing the estate. And so that long-term strategy is not really going to be effectuated with a DIY document, really, a LegalZoom type will. But the main point is you just simply don't know what you don't know. So when I meet with clients for the first time, usually the first half of the meeting, half an hour or so, is educational. So I'm really fleshing out the law in North Carolina, what wills do, what they don't do, what trusts do, what they don't do, what's going to happen to your brokerage account versus your 401k, and what you should do with houses that are in county versus out of county, and how that's going to be impacted by planning and by your death. So that's something that I'm sure you could probably find online if you did a lot of studying and really looked into it and did some research into the law. But by meeting with somebody who does this day in and day out, every single day, they can inform you of those sorts of things very quickly and efficiently. And being fully educated on the process is a substantial part of creating a plan that's going to work for you. So while you absolutely can go on LegalZoom.com and pay $69 and get your will, that's only part of it. Another issue for that is North Carolina has specific requirements as to how a will has to be executed. So for instance, in North Carolina, in order to submit a will to probate, it has to be signed, attested by 2 witnesses, and notarized. So what that means is you have to coordinate 2 people who are not interested in your will. So it's got to be someone who's not a family member or a spouse or anything like that, to witness your signature, and then have a third party also notarize all 3 of your signatures. So the logistics of that can be daunting, especially when you're doing it by yourself, because you've got to inconvenience friends, neighbors, colleagues, coworkers, those sorts of things, to come meet in the same room all together at once, get your will signed, and go down to the bank maybe and have it notarized. Some people don't even do that. Some people just print off the will. They think everything's good to go. They sign it, they put it away, and we don't realize that there's a big mistake until they've passed and their family is now trying to probate everything. So using a lawyer, I provide the witnesses and the notary. So whenever I do a plan, we do a signing meeting, and everything's coordinated there and taken care of, and that's it. I also give my clients direction on what to do next, to the next steps. If they're using a will-based plan, what to do with their beneficiary designations, where to keep the will, those sorts of things, who to inform of the will and where it is. If they're doing a trust-based plan, we talk about funding, how to move assets, how to retitle accounts, those sorts of things. And that's the kind of follow-up that you'll get with a lawyer that you'll never get with LegalZoom. And recently, LegalZoom and Rocket Lawyer have introduced these sorts of contact a lawyer type programs where you pay $30, $40 to have a consultation with a lawyer for like 30 minutes on planning strategies, your will, that sort of thing. Well, that's great. It's better than nothing. But you go back to the old adage of you get what you pay for. So if you're paying a lawyer $40 to give you advice, I don't know of any lawyers who work for less than for that much money. It just doesn't make any sense. So the type of lawyer who will work for $40 is the type of lawyer who doesn't have any other work to do, and maybe they're not the greatest lawyer. Not to throw anybody under the bus if that's what you do, but that's not the kind of quality representation that you would get should you go retain a lawyer locally and do the planning process with them. So if you're thinking about getting a will, it's much easier for everybody involved, you and more importantly your family after you're gone, to do it right the first time rather than trying to cut corners, save a little bit of money, and avoid using an attorney. So much easier to get it right the first time. So seek out counsel, get it done right, and don't use LegalZoom.